also known as Young Thug, is expected to pick back up on Monday, but it's been a busy week. If you're new to the case, just dropped in from another planet, the rapper, along with 5 co-defendants, charged with a whole bunch of gang-related crimes connected to the alleged street gang YSL, short for Young Slime Life. Those crimes ranging from drug distribution and firearms possession to armed robbery to murder. Of course, on the defense side, they say, no. YSL, it's our record label, Young Stoner Life. We just deal with themes surrounding the tough life circumstances we live through. Now, Monday through Thursday of this week were dedicated strictly to the outstanding motions. It was kind of a cleanup day, or 4, from the recently appointed Judge Paige Whitaker. She had to pick up from where Judge Glanville left off when he left the bench last month. And she has wasted no time gathering the parties together to tackle redactions, to hear arguments on misconduct allegations, and to get the next witness prepared ahead of the jury's return, which we hope is going to be Monday. That witness, the key, is Kenneth Lil Woody Copeland. He was on the stand when the trial was last in session, almost 8 weeks. And he is really the core of, remember that June 10th ex parte hearing? That started this whole ordeal. His testimony surrounded the death of YSL gang rival Donovan Thomas, among other crimes in this case. And speaking of Mr. Copeland, he made an appearance, a little cameo on the stand Tuesday. He was instructed by the judge on pleading the 5th. Remember, he's got immunity. And if he pleads the 5th, the consequences of doing so at this stage of the game will be going to jail. Copeland will be back on the stand Monday, we hope, when this case restarts, because he said it depends on how he feels when he wakes up. That's what he said. And the jury will be there. Again, first time in 8 weeks. Court dark today. They're kind of catching their breath, but judge has other commitments. That happens. But a lot has happened this week that we need to catch up on. Judge Whitaker submitted, finally, some written rulings on several motions. It happened last night. A lot of them circulating around that ex parte meeting. Number 1, she's denied a motion for mistrial filed by Doug Weinstein. He's the attorney for defendant DeMonte Yak Gotti Kendrick. Based on the fact that Copeland's testimony will start over, we're going to talk about that. And the former judge behind the ex parte meeting has been recused. Judge Glanville no longer in the mix. Young Thug's attorney, Brian Steele, made a motion to disqualify the prosecutors, Love and Hilton. That was denied, in part because Judge Whitaker doesn't believe there was a Brady violation tied to the ex parte meeting, despite what attorney Steele claims. Now, Judge Whitaker made a very interesting ruling to defendant Shannon Stillwell's motion for a fair and constitutional trial. That's a motion I have never heard of before. It was filed by attorney Max Shard. Here's what she said. There were concerns over the misconduct by the prosecutors and the prior judge, but that could all be addressed on appeal. And the ex parte meeting itself was not improper. As for the claims of late discovery, and we've talked about them, prosecution giving this material too late, Judge Whitaker came up with a brilliant idea, a Brady training session. Yeah, the training will consist of the prosecutors watching a video on the topic under the direction of the court. They got to clean erasers after class as well. So this is a lot. There's a lot to catch up on here. So I think it might be a good idea to just jump right in with my guests to get their takes on these various rulings. So joining me in studio, I have with me Aaliyah Roberts, and Katherine Lizardo is here as well from the Dallas-Fort Worth area. So, whoa. So Aaliyah, let me start with you. Not much happening, as we get ready for, we hope, more testimony, more evidence, the jury back on Monday. Let's just pick one of these rulings. Any of them stand out to you as weird, proper? I'll let you pick.
I think that my favorite ruling, Michael, is the one on the Brady training, right? If you're an attorney, we have to take certain videos, certain ethical videos that we have to watch throughout our training to consider, to have to, make sure that we're doing what we're supposed to be doing, especially when it comes to criminal trials, because life and liberty, right? I think that this ruling that the prosecution has to watch a Brady violation is kind of a Band-Aid on that, right? Like Judge Whitaker continues to refer to the appellate process. If there's an issue, just take it up to appeals. And I think that's the best that she can do under these circumstances, right? Go ahead, I'm sorry.
No. I'm just going to say I think you're right, and I'm hoping they get, CLE credit for watching this video. We all have to take these continuing legal education requirements every few years, depending on the state. Those count. Get 3 units there. I think it's a joke that this was the remedy, but let me ask you, Katherine. I think the judge, and I was talking with producer Heather yesterday about this, we were going through page and line of all these different statements that the various witnesses made to the cops and redacting what needed to be done. I think we'll revisit that a little bit today. You don't go to that effort. This judge does not go through that day after day if in the back of her mind there is a chance in hell that she is going to disqualify DAs or grant a dismissal. What's your take?
I agree. I mean, she is spending a lot of time, like you mentioned, 4 days to iron out as much detail as possible, even though at the end of the day, we still heard there were still outstanding issues that has to be addressed. And the judge told the prosecutors that they have to produce any other information and discovery or witness list that they have not yet produced to the defense, which is very questionable at this time of the trial when they should have all their ducks in a row. I like how the judge mentioned at one point, they have to produce all their ducks and ducklings to the defense at an appropriate time. So she is not thinking about excluding or having a mistrial for this case. It will proceed as it is as soon as they ironed all of these motions.
Yeah, you know, we wonder what Copeland's going to do. You know, is he going to show up Monday? He said, it depends on how I feel when I wake up, which I can relate to. Luckily, I woke up today and I said, I'm going in, and here I am. So whether he says anything or not on Monday, it's a crapshoot. I don't know. Any gut feeling? You've seen this guy testifying, and he is a character, if nothing else. You think he's going to testify?
I think that he's going to get up there. He's going to rub the crust out of his eyes, and he's going to say, I plead the fifth. Just my thoughts. I think
then he's going right to jail.
Correct. And I think that if you're willing to admit to a murder, right, you're willing to say that I committed this murder, I don't think that jail is on Kenneth Copeland's mind. I think that he's sick of everyone. I think that he's tired of asking questions and he just wants to get out of there. You know,
it's funny. If he has to go to jail till just the end of this case, that's all. I mean, that could be a life sentence. Okay. Another issue at play here is the jury. Remember, they've been off for an 8-week vacation. That's a long time. Well, Copeland's testimony was one of the last things they heard. It is expected now to start over next week. Here's how the judge plans to remedy this issue.
This is a chunk of testimony from a couple of days that y'all need to ignore entirely, disregard entirely, don't give it any consideration. What I propose to do in addition to instructing them on that is to then do some version of, and Ms. Persfield found a case that was pretty recent where a court had done this when they were having to say, ignore all that evidence, disregard it. They actually kind of said, and if there is anybody who thinks they can't, let me know. And I would propose to do that whenever I give this instruction, so that if there are jurors who are like, no, man, I just cannot do that. Once I hear it, I can't unhear it. Then we can know that. We could excuse those jurors. And I mean, I guess if it's 8 jurors that say that, then we might have a mistrial. But better to go ahead and figure out from the outset, as far as I'm concerned, can you do that? Instead of just being left with, oh, they're presumed to do it. Okay, so thoughts on that? But it is an appellate court case. Ms. Persfield, do you have the cite for it? It looked like a pretty good idea to me.
So understanding that, well, all that I'm saying is that even if the court brings the jury back Monday, and on Monday Mr. Copeland chooses not to testify, Monday would be premature to tell the jury to disregard what he said, because he may change his mind on Tuesday, and then he comes in on Tuesday and they have to now consider what the court has told them to do.
Undisregard it.
Right.
Yeah, well.
So I would ask that.
Well, let me ask you this. Assuming that we have him in before we have the jury in and he says, I'm good to go, put me on the stand, which he will not say in that way, but we still at that point need to say, as to the 13th, 14th, whatever, disregard that, right? I mean, that's the time to say that, right? Yeah.
Yes.
Okay. So I hear you. It may be that he says one thing on Monday, which is throw me in jail. And then by Friday, he's like, I don't like jail. I want to come testify. Then, yes, they get to consider what he said on the 7th through the 12th or 10th or whenever it was, 12th, I guess. But I don't think we leave them hanging in the meantime.
First, I think Your Honor indicated that you want to make sure that jurors are able to follow the instructions. And so I don't know how we're going to be able to, without telling them to disregard, make sure that they're able to disregard the instructions. Secondly, if there's evidence that they're not supposed to be considering, I don't want them to be evaluating other people's testimonies further on in this trial while still considering something they're not supposed to be considering.
I think so too. I mean, it's not ideal, but it may not come to pass, but I think that at the point in time when it appears to us, if it appears to us that he's not going to testify, we need at that point in time to say, disregard everything you heard from this witness. And then if he later says, you know what, get me out of here, I want to testify anyway, then is when we say, okay, I know I told you to disregard it before, but he's available again to testify, so here's what you can consider. The rest of it, we're picking up from wherever. I just think that's the best we can do.
It's not ideal, and it's the best we can do. I'm not sure those are really the appropriate legal standards, but that's what the court is saying here. And this is all in an attempt to sanitize what happened after the June 12th meeting, the ex parte meeting that led to the recusal of Judge Glanville. And the judge has come up with this instruction that's going to tell the jury, just erase all of that from your mind. Just ignore anything else you may have heard during that time. It's gone, okay? And then they're going to start over. And so that would mean if, Mr. Copeland decides to testify, they'll be hearing that for the first time. So Katherine Lizardo still here, Aaliyah. Katherine, that's going to work perfectly well, don't you think?
Yes, exactly. Well, and I can see how you're setting up that bell, because in the legal world, we have this saying that you cannot unring the bell, which means that once the jury hears something, hears an evidence, sees demonstrative evidence or fact, then it's very difficult to tell someone, forget about that fact that I just told you earlier, or the witness just told you earlier. So if any of the juries come back on Monday and say, I'm sorry, I can't unring the bell, I can't forget what Copeland testified to as to fact A, B, and C, then that's the time that the judge will determine if the juror needs to be excused. And we heard her say that if there's 8 jurors that actually says that, we might not have a choice but to actually have a mistrial. What the judge is trying to do here is to do it by case basis. And she based it on an appellate ruling that actually had a similar ruling as to what to do when a witness is doing something that Copeland is doing right now.
Yeah, so Aaliyah, we've had all these potential off-ramps this judge could have taken, all of these motions to dismiss, to disqualify the DAs, and she has stayed on the highway. She's not let it go. Now she's given herself maybe one more opportunity. But the real question is, will the jury members be truthful about what they can and can't forget? Are they going to want to just be, helpful? Oh, no, Judge, we're fine. We can draw that line in our minds and move forward from there. What do you think?
I think that there is something to mention about the city of Atlanta, right? It's not like Young Thug is an individual who people don't know, right? And even if they don't know him, they've seen this trial play out on TV for months, 11 specifically, going on 12. So to the extent that you have individuals who support Young Thug, that are there for him, that are also on that jury that might not have said in the beginning, I might have heard about this individual. They're going to stick on that trial because they don't want him to go to jail amongst his other affiliates and co-defendants.
Yeah, so we're back to that same problem you have with the jury system, and that is we can't get in their heads. We don't know. There's some people that want to be on a jury for whatever reason they have, and they will say, oh, no, I could be unbiased, and yet they can't be. We don't know what the heck's going to happen here, but it's a matter of numbers. You got 4 alts left. You got 12 in the box. I'm no math major, but you lose 5, you're down to 11, you're done, and that's what the judge is suggesting. I don't know what I don't know what I want. I'm not sure. I wouldn't like to see the erase board wiped off and started new at some point. But we're going to find out. This Monday is going to be great. The weekend is just going to be just crazy with anticipation. We're going to continue to watch this case, obviously, and talk much more about it. Hey, if you followed the Karen Reed trial with us here at Law and Crime Network, even more, well, we've got even more for you. This is a brand new podcast from Wondery Plus. It is out now. Karen explores the divisive theories behind John O'Keefe's mysterious death and takes you through the sensational trial that captivated the nation. The first 4 episodes are out right now, with new episodes being released every week. You can listen to Karen exclusively and ad-free by joining Wondery Plus in the Wondery app on Apple Podcasts. Start your free trial today by scanning the QR code on your screen right now. Okay, let's take a break. We'll come back again. More Young Thug, more Karen Reed. Big hearing today, speaking of Karen Reed, and we'll be right back.